Well, hello, everyone. Welcome to CCI Haronia's webinar, Tenants in Condos. And if this is your first time joining us at one of our Lunch and Learn webinars, well, welcome. And we're so glad that you were able to join us today. We hope that you find today's webinar informative and that you'll consider joining us on a regular basis. If this is not your first time and you're coming back again, well, welcome back. And we are also so glad that you were able to join us again today. Thank you for your support and taking the time to spend your lunch hour with us. For those of you that don't know me, I'm Sonja Hodis, and I'm one of the many directors at CCI Haronia, as well as a condo lawyer and your moderator today. Before we get started on our topic, I want to take this opportunity to thank our sponsors for their support. Without their support, we're not able to offer these webinars free of charge to all of you. So thank you to our sponsors, Macintosh Perry, Registon Building Restoration Limited, Common Ground Condo Law, Brown & Beatty, and Elia Associates Condominium Lawyers. If you want to find out any more information about these sponsors, you can go to our website, and on our landing page, you'll find the logo of the sponsor, or you can go to the event page and find their logo there. If you click on their logo, it'll take you directly to their website, and you can find out more information about them. So thank you again to our sponsors. So who is CCI? Well, we are the Canadian Condominium Institute. We are an independent nonprofit organization formed in 1982. We have chapters across the country, and in Ontario, we have 8 chapters alone. CCI is one of the Ontario chapters. CCI Haronia is one of the Ontario chapters. CCI's main objective is education. However, CCI also advocates for condos, and we represent all those involved, from owners to directors to professionals, and we encourage all of these stakeholders to work together. If you're not a member of a CCI chapter and you want to experience the benefits of membership, you can become a member of the CCI Haronia chapter by going to our website, cciharonia.com. You can register online for membership. If you want to become a member of another chapter, in addition to CCI Haronia, or in the alternative, check out the CCI national website, cci.ca, to find a local chapter near you. Also, if you want to find out more about membership, I'm going to put some information in the chat box a little bit later. CCI National has a resource center available on the national website, cci.ca, that has a great deal of material available for review relating to condo issues. You can access that National Resource Center from the national website, or you can just go to the CCI Haronia website under the Resource Center tab, and you'll get a direct link to it. It's a great resource of collections from across the country and our various chapters. Also, don't forget to like CCI Haronia on Facebook and join us on LinkedIn. It's a great way to find out about our upcoming events. Also, just go to our website, cciharonia.com, to find out what's happening in our chapter, and also to get a copy of our newsletter, Condo Buzz. If you've missed any of our previous webinars, webinar recordings of all our past webinars are found on our website under the Resource Content tab. And today's webinar is being recorded and will be posted to the website in the next 7 to 10 days. If you're watching those webinars on YouTube, don't forget to subscribe to our channel, hit the thumbs up to show us when you like show us that you like the video, and don't forget to share these videos with anyone that you think may find the information important or beneficial. So today we're going to talk about tenants in condos, and you might be saying to yourself, why are we covering such a topic? Well, according to a recent StatsCan report that was released on February 3rd, 2023, that report found that condos are used more as an investment than houses are. And Ontario topped the list of provinces with the highest rate of condo units being used as an investment at 41.9%. In addition, most of the newly built condo apartments are being bought by non-occupying owners. In 2020, almost 60% of the units that were built since 2016 had non-occupying owners. And this is not just a big city issue. Small cities like Woodstock and London saw 80 to 100% of their newly built condo units being bought by non-occupying owners. Barrie, almost 50%, and Aurelia, almost 45%. While some of these non-occupying units are likely sitting empty with no one occupying them, many of these are being occupied by tenants. So instead of just dealing with owners who have a financial investment in the condo corporation, condo boards and property managers are also having to deal with numerous issues that are raised when you have tenants living in a condo. They come to the table with a different set of needs and wants, and the role of the condo versus the role of the landlord owner often gets blurred. As the number of condo units being used as rental units appear to be ever growing, the issues that condo boards and property managers must navigate also becomes more complex. So today, what we're hoping to do is share some thoughts, advice, and insights into issues that condo boards, owners, tenants, and property managers must consider when dealing with condos that have owner-occupied and non-owner-occupied units. But before we get started and we start with our first speaker, I want to take a moment and ask you a question. How many units in your condo are occupied by tenants? You don't know? 0, less than 15%, 16 to 30, 31 to 50, more than 50, or 100%. And although you don't know this is probably a test to see whether or not you've actually read your most recent PIC, because this information would be contained in that document. So it looks like most condos are 16 to 30% occupied by tenants. Give everybody just 2 more seconds and then we'll close the poll. All right, so the results are 15% of our participants don't know if they have condos, units that are occupied by tenants. That's interesting. 1% have 0. That's a very, very small number. Nobody has 100% of units occupied by tenants. The most is in the 16 to 30% range. We have 36% of participants today answering in the 16 to 30% range, followed by 28% of less than 15%, and 31 to 50% comes in at 15% of our participants. So as we can see from the stats collected by StatsCan and our own informal poll that we did today, we can see that tenants in condos is an issue that almost every condo is going to have to deal with. Some will have more, some will have less, but regardless, if your condo even has one tenant living in a unit as opposed to the owner occupying the unit, you will want to listen to the great lineup of speakers we have today as we touch on various issues that boards, property managers, owners, and even tenants should be aware of. We're going to be covering how to deal with owners who are landlords and where to set the boundaries, how to make sure tenants comply with the rules, and how to create a relationship with tenants, clauses you need in your leases if you're an owner, and what you should be putting in your governing documents if you're a condo. What is Section 83? Why is it important? And what does the CAT say about it? The types of insurance that owners, tenants, and condos need, as well as things to consider when it comes to enforcement and tenants. But before we get to our first speaker, just a reminder, keep your mics muted. If you don't want to be seen, please turn off your camera. If you have any questions, put them in the chat box. Our speakers will be monitoring the chat box and we'll be trying to answer those questions throughout the webinar. Also, the information being provided today is general information and may not apply to your specific fact situation. If you are a condo director and want to use the protection of Section 37 of the Act, you will need to get an opinion about your specific fact situation from your own professionals. The webinar is not intended to provide you with opinions that would protect you under Section 37 of the Act. In addition, because this is being recorded and may be viewed at a later date, the information provided in this webinar is current as of February 24th, 2023. Things change rapidly in this world, so the information provided today may not be relevant at a later date. Make sure to check with your professional to make sure that the information is still current. And finally, any references to legislation or the Condominium Act in today's webinar is reference to Ontario legislation. So let's get started with our first speaker, and we have Sheila Krivsky from Hodis Law Property Management. Sheila is a property manager, and she's going to talk to us about how do we deal with owners who are landlords and setting the boundaries between what owner landlord needs to do and what a condo board would do. Sheila?
Thanks, Sonja. So before considering entering into a lease, condominium owners should review corporation governing documents and municipal bylaws to ensure that they won't be in contravention by leasing their unit. Some condominiums may have rental period minimums or other restrictions, so it's best to consult with your property manager if you're unsure. Property management has the responsibility of communicating directly with the unit owner rather than with the tenant. The unit owner is responsible for the actions of their tenant, including ensuring that the tenant is adhering to the condominium's governing documents, such as the declaration, bylaws, rules, and policies. There can be tenants that fit right in and engage in events and interests of the community, and there are tenants that are quite the opposite. Property managers often receive complaints or requests from tenants that should be directed to their landlord, the unit owner. From there, the unit owner should connect with the management company if it's determined to be condominium responsibility. It's important for landlords that own condominiums to advise their tenant that communication is to be directed to them rather than the management company. Some management firms have made provisions available that include tenant access for things such as general notices in online platforms and may include access to community websites. This doesn't replace the landlord's responsibility to ensure that any information that relates to their tenant makes it to them, and addressing any concerns that may involve their tenants. The condominium corporation will address concerns regarding a tenant directly with the unit owner. The onus is on the owner to remedy the situation. It's important as well for the condominium or the property manager to communicate the concerns to the owner in writing, because if the owner doesn't remedy and concerns continue, it's then up to the board's discretion to involve legal counsel to consider further action based on the nature of the concern. And Sonja will be discussing enforcement consideration later on in this webinar. The management company is not responsible for assisting with interior repairs and maintenance that are defined as owner responsibility within the declaration Schedule C. The corporation would not accept requests to make change to the common elements or enter into a Section 98 agreement with the tenant. If a tenant was looking to make such changes, they should be directed to their landlord as the unit owner, and the unit owner would then make change requests and be responsible for those changes should they be approved by the corporation. Should a tenant make a change without approval, the unit owner would then be responsible to restore at their expense. Tenants are not permitted to attend homeowner meetings, such as annual general meetings or special general meetings, unless they've been assigned as a proxy holder for that particular meeting. It is the sole responsibility of the unit owner to assign their proxy to their tenant if they choose to have their tenant take that position on their behalf. The owner would be responsible for asking the management company for help completing it if they were unsure how to fill it out, and ensure that their tenant can act on various parts of the meeting to the owner's level of comfort or preference. It's imperative that landlords give tenants the opportunity of putting their best foot forward. Condos need to communicate, and owners need to communicate clear expectations and channels of communication before a lease is signed for tenancy. Once the tenancy agreement is signed, the landlord's required to notify the condominium corporation and provide a copy of the lease within 10 days of entering into that agreement, and any additional information as requested by the management company. Most management firms have forms to help facilitate the collection of tenant information, and the Condominium Authority of Ontario's website also has a summary of lease form that's available. The owner should also advise when tenancy is terminated. The management company and condominium corporation are not responsible for ensuring that communication that was authorized cease with the tenant should the owner not notify that the tenancy is over. Landlords should also consult with their insurance broker to make sure they're adequately covered, which Tricia will speak to next. If you're a landlord and you're unsure of whether you've set up your tenant correctly, absolutely connect with your management company and they can confirm or help you through this process.
Thanks, Sheila. So you've talked a lot about from sort of the landlord as owner perspective, but what about tenants? What can property management do or condo boards do to sort of create relationships with tenants, make sure tenants are complying with the rules, the declaration, the bylaws, because they are part of the community. And so how do we deal with that? And what are your suggestions?
Sure. There's certainly benefits to building relationships with tenants. If there was a situation where an owner wasn't paying their condo fee, the corporation go to the tenant and obtain the funds out of the rent that they would have paid to the owner, and any leftover going to the owner. But it helps make that process easier when management has a relationship with the tenant. Some ways of helping build that relationship would be finding ways to include them in the community. It might be in a section of a corporation newsletter that's geared to tenants, or including them in community events such as barbecues, game nights, really any type of community event. There are some buildings that are highly tenanted, and leaving the majority of the residents out of the loop doesn't encourage the feeling of a single community within the property. And that's what you don't want to encourage, is an owner-tenant divide between residents. Tenants are just as much living on the property as a resident owner is, and they have the same rules to follow. And we want to encourage tenants to care as much as an owner that has an invested interest in the property. It makes it more likely for a tenant to reach out to management and say, hey, the hot water isn't working, in a building where the hot water comes from the corporation's equipment, or letting us know that, garbage bins are overflowing, giving management that information sooner than if they just chose not to reach out and expected that maybe a unit owner would. This, of course, does not replace the need for tenants to advise their landlords, because there will continue to be situations where the responsibility lies on the owner. There could also be consideration by the corporation to build a tenant welcome package of sorts for owners and for owners to provide to tenants, with details of the corporation, community, who to contact for what tenant contact info to provide to management. It's great when both the tenant's email and phone number are provided, and anything else the corporation may find relevant. Down the road in the tenancy, the corporation may need to contact the tenant to address condo fee arrears, discuss infractions, etc. And having that information from the get-go is definitely going to eliminate any difficulties obtaining it once it's needed. And really helping owners gain the knowledge they need to become landlords and leasing their units, and also knowledge for those tenants to be able to fit into the community is the goal. Just as there's owners that will not always use that knowledge when residing in condos, that will continue to be the case for tenants, but it's giving them a chance to put their best foot forward, and then including them as a community resident.
Thanks, Sheila. Yeah, I think you make two really good points. The us versus them, that's really important, that we create a whole community and not have these divides of owners versus tenants. You see that happening sometimes, and it just creates conflict and problems down the road. So welcoming tenants in and making them part of the community is really a good tip there. And also education. I mean, CCI says this all the time. Education is so key for all members of the community, and making sure that tenants are aware of what their obligations are, owners as landlords know what their obligations are, is so important. So finding ways to educate owners and residents is a great way to have a nice community who can all work together and work toward a common goal. So thanks for those tips, Sheila. We're going to now turn over to Tricia Baratta, who is one of our condo insurance experts. She's from our CCI London chapter, and she's joining us today. She's going to talk about insurance considerations that owners, tenants, and even condos need to think about when we have non-owner occupied units in our buildings. Tricia?
All right, thank you very much, Sonia. Okay, so let's add a tenant policy to an already complicated insurance claim process, shall we? When tenants are involved with condo units, there are now 3 policies involved versus 2 policies. When we had the condo policy and the unit policy, now we're going to throw the tenant policy in there as well. So sections 99 and 102 of the Condo Act state what the corporation shall insure, and those typical coverages, I'll be brief, but property, general liability, equipment breakdown, also known as boiler and machinery coverage, directors and officers, you may have heard D&O, expressed as D&O, legal expense, and most recently, cyber and privacy liability. Going back to the property coverage for the condo corporation, though, because this is the portion that is most often triggered in a claim, the corporation's property coverage must include the common elements, so those items listed in Schedule H of the corporation's declaration, and they should also be listed in the Reserve Fund study plan, roofing, HVAC, that sort of thing, elevators, garage doors, depending on the condo corporation. The property coverage should also cover those standard unit finishes, so not any of the betterments and improvements that may have been done to the unit above the standard unit description. And then there's other recommended property extensions that don't relate to a tenanted situation, but unit owner's coverage will change when going from an owner-occupied arrangement to a leased unit arrangement. The condos isn't going to change, regardless of how many units or if you have tenant units in your property. The condo corporation's coverages must stay the same, but the unit owner, when they go from a unit owner-occupied spot to a tenant in their unit, it will change. So the unit owner will have in their policy, or should, betterments and improvements. So that's anything, again, anything above the standard unit description in the standard unit bylaw. Their contents, so whatever's not attached to the unit. Additional living expenses, should they need to vacate the unit for repairs to be made. Deductible or loss assessment, excuse me, and then their own personal liability. Sorry. So when the unit's leased, all the same coverages are in place except the additional living expenses. We're going to push that onto the tenant and part of the content. So the unit owner, when they've leased the unit, they're still going to need betterments and improvements. That's still their responsibility. That's the stuff that forms the unit that is above the standard unit description. So those fancy countertops, those fancy floors that didn't come in the standard unit. The unit owner can lower the contents limit because their personal property is no longer inside, but they still have appliances and those things that need to be repaired in a loss. Deductible loss assessment still there, and the personal liability is still there. But what we do with the tenant, and it's so important that the tenant provides proof of insurance to the unit owner. There isn't anywhere in the Condo Act that says the tenant needs to provide, but it's very, very important for the unit owner to require this of a tenant. And the reason being, the content, whatever the tenant has brought into their unit, yes, they're going to have to cover that. They're going to have to make sure that that's insured in the event of a loss. But when it comes to the unit owner and the condominium's concern, we want to make sure that that content, should it be damaged in a loss, can be removed from the unit and that there's coverage for that. We don't want the condo corporation or the unit owner to have to take care of that bill. We want the tenant's policy to cover that. We can't clean the unit, we can't repair the unit when it's got stuff inside it. And then additional living expenses, we want the tenant to have that. So we want to make sure that the unit owner doesn't have to pay for their tenant to be in another place while that unit is being repaired, should there be an insurable loss. And then the tenant should also have their own personal liability. So takeaway, when the condo has rentals, a couple things, the insurance on the condo stays the same. The condo corporation's insurance will stay the same. However, the higher the ratio of rentals to unit owner-occupied units, the higher that ratio, the greater impact it will have on the condo's premiums. So right now, it's about 50%. So if you've got about 50% rentals within a condo corporation, you're definitely going to see an increase in the premium that's allocated to that property coverage and liability coverage. And it also does decide, some insurance companies actually won't even write a condo policy if they have above that threshold.
Thanks, Tricia. Well, that's a lot of insurance in 5 minutes or less. But some, important takeaways that it doesn't affect the condo's insurance, but it does definitely the owners and the tenants. There is a question in the chat about insurance. There's an interesting little situation there. You might want to take a look at that. But we're going to move on to our next speaker. And we have with us a new guest. This is the first time she's been on one of our webinars, and we're so glad that she was able to join us. We have Natalia Polis, who is from Lash Condo. She's a condo lawyer, and she's going to talk about Section 83 notices and what those are, why we need them, and what CAT says about them. So, Natalia?
Thanks, Anya, and I'm happy to be here. Thanks for the invitation. Okay, so what is Section 83 of the Condo Act? Section 83 is essentially a three-part provision. Part one of the provision requires that an owner of a unit who leases their unit or renews a lease of their unit has to, within 10 days of entering into a lease or renewal, notify the corporation that their unit is leased. They need to provide the corporation with the lessee's name, the owner's address, and a copy of the lease or the renewal or a summary of it. The last part that is the owner's responsibility is to provide the lessee with a copy of the declaration, bylaws, and rules of the corporation. The second part of this provision also requires owners to provide the corporation, again within that 10 days, notice if a lease is terminated. And that's 10 days within the date that the lease was terminated. The third part is an obligation on the condominium corporation to maintain a record of the notices that it receives under this section. So notices related to termination, renewals, or leases. So why is this important? Why is it so important for corporations, especially, to maintain these lease notices or termination notices? Well, there are multiple responses to these questions. Firstly, it is important for corporations to know who their residents are, both for security purposes and generally for the community, as we discussed earlier. Secondly, it is important that owners provide their tenants and their tenants receive copies of the declaration, the bylaws, and the rules, so that they are aware of what is and is not permitted in the corporation. Thirdly, it provides the corporation with the contact information for the tenants in case there are any rule infractions or infractions of the declaration, the Condominium Act, etc. This allows management or the corporation solicitor to be able to communicate the rule infraction to both the owner as well as the tenant. It also provides management the ability to communicate with the tenants directly. For instance, when I was a condo tenant and resident, I received emails and notices for fire inspection, elevator enclosures, so I was kept apprised of what was actually happening in the community. Fourth, it also helps the corporation to know who is an offsite owner or not. This is important, especially when there is an owner-occupied position up for election. Offsite owners would not be entitled to vote for that election. On that token, it also affects the eligibility of some owners to run for the election if there is a specific qualification in their bylaws that requires them to be an owner-occupant. In some circumstances, I've seen an owner get elected onto the board, and then subsequent election, we found out that he's not an owner-occupant, and that's the specific qualification in the corporation's bylaws. So that owner was unfortunately immediately disqualified from the board once we received that information. This could leave the corporation in a precarious position. It could lead to a vacant position, or worst case scenario, there's not that many directors on your board, you could be without quorum. Sixth, condos also need this information for their status certificates and their periodic information certificates. Both these certificates require that the corporation identify how many units are leased in the corporation. I oftentimes see owners ask board or management at AGMs how many units are leased in our corporation. So it's good to have that information readily available. Another really important and timely reason why it's important to maintain these records for the corporation is because of owners' requests for records. We're seeing ever since the CAT received jurisdiction over records disputes, owners are bringing these disputes left, right, and center, especially in terms of Section 83 notices. Owners are entitled to receive records related to Section 83 of the Act. These records are considered core records that the corporation must maintain. But now the question is, what exactly does the corporation have to maintain in terms of these Section 83 notices? Are owners only entitled to a list of the unit numbers that are leased? Are they entitled to the actual copies of the notices or the renewals or the summaries? What are they entitled to? Well, the Condominium Authority Tribunal has clarified this for us in the case of Chai versus Toronto Standard Condominium Corporation number 2431. In this decision, CAT held that Section 83 requires the corporation to maintain a list of each unit in the corporation for which one or more notices under Section 83 has been received. Two, for each unit in that list, an indication of the type of notice it received, so whether it was a notice of lease or a renewal or a summary or termination of the lease, and the date on which the notice was received. CAT also held that the record should not only include the units that are currently leased, but also include all units for which one or more notices have ever been received. I find this a rather odd result, in my opinion, because I don't know why any owner would want to know about a lease that was terminated 5 years ago, but hey, that's what the CAT held, and that's what we're following right now. In the decision, CAT ordered that the condo had to provide the applicant with a copy of the updated record within 30 days. What exactly this includes is not really clear, but we do know that any information that pertains to the specific units under Section 55(4)(c), so for instance, the actual tenant's name, are exempt from production. So what are some lessons learned about Section 83? The number of leased units should equal the number of notices received. If the corporation has not received a lease, it should not include the information about the unit being non-owner occupied in the information certificates or the status certificates, or disqualify the person before they're even a candidate for owner occupied positions. Even if the board and management know that the unit is leased, you do not enter that number unless the corporation receives that notice. One way to rectify this, though, if you are aware that a unit is being leased and you have not received a notice, you could write to the owner and try to obtain that information. However, again, it's not required to, the corporation is not obligated to reach out to the unit owner. The unit owner is obligated to reach out to the corporation and provide that information. Secondly, adequate and accurate record keeping is important in terms of Section 83. I know that many of clients were shocked when they found out that the corporations had to keep records of notices of termination and the dates that they were terminated in this list of leased units. So if you have not been doing that in the past, something that you should start doing moving forward. Last but not least, one helpful tip, and this comes out of a CAT case that I was a part that actually ended up settling. It was specifically about Section 83 notices, and a unit owner was quite concerned about the adequacy of the Section 83 notice. They were aware of multiple leased units that were not listed, and were concerned that the corporation wasn't taking adequate records. In this case, the corporation sent out a notice to all owners, simply asking, if you have leased your unit or terminated your lease recently, can you please notify the corporation and provide that relevant notices and information by so-and-so date? The corporation received multiple responses and were able to update their records accordingly. And now moving forward, if any owner requests a record under Section 83, they have an adequate and complete record that they could provide its owners upon request. It's a pretty simple step that could help corporations maintain the most precise and accurate records in relation to Section 83.
Thanks, Natalia. There's a question in the chat, and somebody's just asking if you could just repeat what you said about not counting units as leased if you haven't received the Section 83 notice.
Yes, so if you have not received a notice from a unit, but you know that the unit is being leased, you shouldn't count that unit towards your total count of leased units that you would include in a status certificate or an information certificate. You don't have the actual record of the lease, even though you are aware on face value that a unit may be leased. You shouldn't include that as a number in the total leased units.
All right, thanks, Natalia. And I see that there's actually a question in the chat about making requests under Section 83. So I'm going to let you answer that in the chat itself. And we're going to move on to the next speaker, which is Patricia Elia, who everyone knows Patricia Elia. She's been on our webinar. She's been on our board for a long time. Patricia is a condo lawyer with Elia Associates, and she's going to talk about what you need to be putting into your leases if you're an owner landlord, and what the condo corp should be putting into their governing documents. Patricia?
Thanks, Sonja. Good afternoon, everyone. And this topic is close to my heart because I not just a condo director, I happen also to be a condo landlord. So I take the leasing component very seriously. And I think we need to set up our communities for success and keep our eye on the ball as to how we can make sure that the community moves forward. So in terms of what you should put in your lease, and we're only talking about residential leases, we're not talking about commercial tenancies, which is regulated by different legislation. I think what is really important is that the premises are correctly identified and an acknowledgement that the tenant will be clearly bound by the Act, declaration, bylaws, and rules as amended from time to time. And why is that? Because you want to confirm the fact that a unit owner cannot grant a greater interest in land than what they themselves hold. And so while, for example, some people may say, well, I'm entitled as a tenant to have a pet. No, the case law has shown that When you buy into a condo and a condo does not allow pets, that will actually be a restriction around the landlord's ability to lease. And what we have to remember is that the landlord-tenant relationship is a commercial relationship. So all of the responsibility should lie on the shoulders of the landlord to enforce compliance. But at the same time, where there is behavior that's unacceptable being, let's say, undertaken by the tenant, you need to appreciate, and Sonja will talk about this, how to enforce properly. So further, what you want, though, is where there are behaviors that cause damage, you want an indemnity clause that is robust. Robust in that it will ensure that the tenant acknowledges that they will be responsible for the consequences of their actions in accordance with the leasing obligation. Okay, so here's the thing. And this is where the framework of the corporation also has to be done properly. The deck, the bylaws, and the rules should contemplate where you do have tenancies possible, that your infrastructure, your corporate governance is actually meeting that possibility. So your declaration should have an indemnity that's robust, that includes indemnification obligations by the unit owner for any costs that are incurred by the corporation that deal with compliance, but not just compliance of the unit owner, their guests, their tenants, etc. Okay, so that is something that we're seeing is a valuable deck amendment that should be in your declarations. Bylaws as well. Bylaws can create parameters, but not about the number of units. So just so we're clear, it's not that you can say by bylaw, we're limiting the number of tenancies. The right to lease your property is inherent in the real estate rights, and it's never really been challenged. Some people try it, but I don't think it will be upheld because in Ontario, we value the ability to own real estate and the rights that come with that. So what you do, though, is manage through your bylaws and your rules the mischief that could be possible. And so in that sense, I think making sure that your bylaws anticipate tenancies is important, that your rules encompass all residents, because that is the person who's living there. To go back to Sheila's comment, you want everybody to be included, everybody to be aware, including the tenants, but they also have to comply like everybody else, right? So that is important. Sometimes you might want to think about a guarantor or a surety. You should have, for your own benefit, a reference. It may not form part of the leasing contract, but it can be a cross-reference component. Also, provision of emergency contact information in the event that there's an emergency. Now, it depends on the emergency. The unit owner should be the first person, of course, to respond and take responsibility. But one of the things we're seeing is when we have offshore owners, they're not always easily accessible or contactable here, even in Canada, for example. So figure out a methodology. Some people say your emergency contact information for the tenant must be somebody that's located here in Canada. Okay, that's easily accessible to us. Similarly, you may want in your rules or in your set of policies, when you have a tenancy, please provide us with an emergency contact person other than the unit owner who is residing here in Canada, so we can contact them pretty quickly. Also, a method of ensuring that the tenant is provided with notice. Now, I think Natalia and Sheila brought this up in their comments, but get that permission slip in, which is, in the welcome package to the tenant, here's our email, authorization form, and have that signed by your tenant so that communication is easy for you. Your tenant wants to know that the garage will be closed. Your tenant wants to know that their unit is going to be inspected for fire compliance, right? So it's important to have that communication so that you also fulfill your obligations as a landlord under legislation applicable to the tenancy. And as well, again, and as part of 83, have an acknowledgement that they received the deck, the bylaws, and the rules, and that they read them and that they understand them. You have to comply with the act, but it's important that you, in your contractual relationship, show that you've actually delivered that, because that's the standard you're going to be held to as a landlord. And so to me, it's all about making sure that the environment is architected in a way so that we can embrace and bring together these relationships and make people part of the community, but that the boundaries are clear. The other thing, too, though, that is, I think, important to appreciate, again, it's a commercial relationship. The buck stops with the land owner, the unit owner, as the landlord. So the corporation's resources, and I have a very strong position on this, is that our property management resources, et cetera, are for the benefit of unit owners and the community. And tenants have to be part of that, of course, as residents. But I think it's unfair when landlords expect property management to manage their rental relationships unless they are engaged to do so, right? And they are being paid to do so. So we have to be also thoughtful as landlords as to the parameters of how far we expect other people to take on those responsibilities for us when it's really our duty at the outset. And that's it, Sonja. That's what I've got.
Great. Thanks, Patricia. And that last point, that kind of, marries into what Sheila was talking about, but I think it's a really good point to reiterate and bring to everybody's attention is that there has to be that clear boundary about what is the landlord's responsibility, what is the condo's responsibility. And, we see so many times in cases that come before us, this blurring of the lines, and that's what creates problems. And it also creates a lot of costs for the condo. So set those expectations, those boundaries very clear up front, educate people about them, and hopefully that'll make everything run a little bit smoother. All right, so we're going to move on to our next topic, which is enforcement considerations when dealing with tenants in condos. And I'm going to talk about this. And I was thinking about how I was going to talk about enforcement because enforcement is so unique to every situation. And so, telling you how to enforce a specific issue, we just don't have time in today's webinar to do that. So I thought I'd come up with my top 10 considerations when dealing with enforcement issues and tenants. And so here's my first one. And I think this is the golden rule when it comes to enforcement, when you have a situation where there is a tenant involved. And that is that you must make sure that you notify the tenant and the owner of the breach and the corrective action that must be taken from the very beginning. I see this so often that condos, they'll send a letter to the tenant, but they won't notify the owner, or they'll send a letter to the owner, but they won't notify the tenant. And so it's really, really important to make sure that right off the bat, right from the very beginning, correspondence, communications are sent both to the tenant and to the owner. There's three people in this relationship. Everyone has to be part of the discussion from the beginning. And then my second consideration is never breach rule number one. And the reason for that is the failure to follow that very first golden rule is going to cause problems for the corporation when they're looking to get reimbursement for their costs against the owner. And it's also potentially going to cause problems of getting an order of enforcement against the tenant if the tenant hasn't been part of that process or been made aware of the breach to begin with. I think it's dangerous for condo corps to just rely on owners to communicate the breaches to their tenants. It's just as easy to add the tenants to the correspondence to make sure that they are aware of the breach and what needs to be done from the very, very beginning. We have cases that have not awarded costs against owners when the owner wasn't notified, and we have cases where there have not been enforcement provisions ordered against tenants who weren't notified of the breach. So we do have some case law that supports the importance of notifying all the parties from the beginning. So my third consideration when we're talking about costs, and Patricia kind of talked about this when she was talking about the governing documents, the condos docs, but it's so important to update your indemnification provisions and to specifically state, I think, and I've been doing this with the revisions that I've been doing for my clients for the last little while, is to specifically state that the owner is responsible for any costs incurred by the condo, even if the tenant is in breach, and that the condo is not required to collect from the tenant. Unfortunately, we've had too many CAT cases where CAT is ordering costs against the tenant and not the owner, which makes it really difficult, if not impossible, for the condo to actually collect these costs As you probably know, if there's an order against an owner, we can add it to the common expenses, and we have a lot of tools under the Act to collect common expenses, but it's very hard to collect against a tenant. So in essence, ordering a cost award against the tenant is really like not ordering costs at all. So by drafting specific language in your governing documents, that makes it the responsibility of the owner to pay these costs, even if the tenant causes the damage or the loss, hopefully will help in future CAT cases if that's where you find yourself. And we have a recent case from February of this year, TSCC 2804 versus Macaulay, which provides some hope for condos in terms of cost indemnification. But it's very interesting that the language in that declaration of that condo specifically said exactly what I said you need to do in terms of updating your own documents. So my recommendation is you update your declaration, because that is where the Act requires the indemnification provision to be. But we do have some cases that also enforce the indemnification provision in the rules. But if you have an opportunity to update your deck, that's where I would start. My next consideration is to make sure you get completed tenant and owner information forms. So Natalia talked about Section 83 and the requirements of the owner to provide information when units are leased. And although there's no obligation on the condo to collect that information, I do think it's very from a practical perspective, I think it's really important to get that information and get those completed tenant and information forms updated on a yearly basis, so that you have the update information of the owners, phone, email, mailing address, the updated information for the tenants, so that you can contact them if there's a problem or if there's enforcement issues that need to be dealt with. The next thing in terms of my considerations, number 5, is to give owners a reasonable opportunity to take steps to fix the problem. So when you send the letters out and you tell them there's a problem and that they need to fix it, the tenant's breaching some rule, then you need to give them some time you need to give the owner some time to allow them to actually correct the problem. If you don't do so, there's a good chance that that's going to affect your ability to be reimbursed for costs. And we do have some cases that have had some negative cost awards, or not very successful cost awards for condos, when they didn't give the owner the opportunity to fix the problem. And on that same thought, my tip number 6 is when owners are taking steps to try to evict a tenant under the Landlord and Tenant Board, be cooperative with the owner and provide them with the evidence and information that they need to help get that eviction. And we do have a case in which a condo corp didn't cooperate with the owner who was trying to evict, and that was held against the corporation. So work with the owner if they're trying to take those steps. We all know right now that getting a hearing in front of the Landlord Tenant Board takes a long time. So it's not a fast process. So work with the owners if they're trying to actually take those steps to correct the problem. So number 7, know your boundaries. So it's really important to understand when it comes to enforcement and dealing with tenants in condos is that there's no contractual relationship between the condo and the tenant itself. So we don't have, as a condo, we don't have any standing at the Landlord Tenant Board. The condo cannot bring an application for eviction at the Landlord Tenant Board. That's something only the owner can do. But the condo has the ability to deal with the tenant under the Condominium Act, and its ability is limited to breaches of the Act and the governing documents. So as Sheila talked about, if tenants want to make changes to the unit, the owner needs to make that request. So know where the boundaries are. If the tenant wants to make changes to the common elements, the owner needs to be part of that process and make that request. So know what can and can't be done by who. Along those same lines, my next tip, number 8, is to make sure that you're naming the right parties in legal proceedings. So tenants are not allowed to bring applications against owners or the condo under CAT. Only owners and condos can bring applications, and they can bring applications against the tenants. So when you're bringing a CAT application, it's really important that you are naming both the tenant and the owner as respondents in those applications. Same applies if you're bringing a court application. And number 9, remember that eviction is a very extreme remedy, and you need to know where you can go to get it. So If we look at CAT has no authority to evict a tenant. That's stated specifically in the legislation in the Condo Act, but courts can remove tenants under Section 134(4) of the Condo Act if the tenant has contravened an order under Section 134 or has not paid the amounts due under Section 87 of the Act. And that section deals with when an owner is in default of common expense fees, a tenant can be notified to direct basically their rent to the condo. So Section 134(4) and the power of the courts to remove tenants is still law, but just note that there are proposed amendments to the section, and that would be Section 135.1 is the proposed amendment, but that is not yet in force. And courts have upheld the ability of condos to permanently remove tenants. We have a case from March of 2022, MTCC 1260 versus Singh is an example of where the courts are still prepared to do that. Number 10, speaking of Section 87, I think this is a really important consideration when dealing with enforcement in tenants, but it doesn't have to do with enforcing something against the tenant. It's about enforcing the condo's ability to collect unpaid common expense fees. And I always like Section 87. I think of it as the condo's secret weapon when it comes to collection of unpaid common expense fees, because Section 87 is another enforcement tool that a condo can use only when a unit is actually a rental unit. And what Section 87 allows, as I said, was to allow the corporation to notify the tenant that they need to take their rent, not pay it to the landlord, but pay it to the condo corp to cover the arrears. So this extra remedy is something that's special when you're dealing with tenants in units that are rented. So just keep that, don't forget about it. It can be a very successful way to collect unpaid common expense fees. I've had some great success using Section 87 in situations. It doesn't eliminate your ability to lien under Section 85. It's just an additional remedy. And my bonus is, like with any other enforcement issue, it's really important to document. I say that all the time. You never know where a breach that starts off as a breach, where it's going to end up. So just make sure that you're documenting everything from the very beginning. Don't just rely on face-to-face chats or telephone calls without documenting them. Take pictures and secure video surveillance if it exists. Get witness statements at the time it happens. So those are my top 10 considerations when it comes to enforcement in dealing with condos. So let's take a look at our chat box, and I think we have a couple questions there. There was a question, Patricia, about a tenant wants to be on the board, but the governing docs are not clear. So can a tenant be on a board of directors?
Oh, absolutely. A tenant can be, as well as a person who doesn't reside at the condo and even not a unit owner necessarily can be on a board. So what you need to do is you need to look at your bylaws and hone who you think is the appropriate person to sit in the position of directors. But I think Natalia brought up a good point, is that sometimes if we restrict and narrow our pool, we may not have anybody. So I think it's something to think about because, for example, in my condo, they were contemplating restricting who could be a director on the board of directors to only people who resided in the condo. But I did point out to them that I had sat on the board for 15 years, did not live there, and contributed. And so the bylaw in the end didn't pass because I think everybody realized, oh, we could be narrowing our scope. But this is why the information about who's running for the candidate's position is really important to understand what their connection is to the condo. And some tenants, I can honestly say, are actually interested in the well-being of the corporation and could actually add value on the board. So it's also, could you limit the number of people who are tenants on the board or not owners? Yes, you probably could do that as well. So it's something that you can work with council on to design and develop.
Thanks, Patricia. And I think we have time for one more question. It's a double question in the sense that I'm going to ask Tricia and Natalia to tackle this one. Tricia from the insurance perspective and Natalia from the legal perspective. But it's a question from Larry, and he says, we have an owner who rented his or allowed someone to use his garage which is in violation of our declaration. There's the legal part of it. What insurance would be required? And if he's not renting, but lets this person use the garage, would the guy using the garage be a tenant? So Tricia and Natalia, who wants to go first?
Yeah, I can go first.
All right, Tricia.
That's a good question. And the answer is, it's all up to the unit owner and the person that's residing in the unit what their arrangement is. So the condo, I mean, the legislation and the requirements of the condo, that's different. You just have to make sure as a unit owner that regardless of who is inside your unit, if they are bringing their own property into the unit, that's covered. So you don't want to be taking on that risk of that property if you don't have to. We always say as brokers, we transfer risk, move it off yourself, put it on the next, right? And if you can, you definitely want to get that person, if they're staying and bringing things, to have a tenant policy.
Thanks, Tricia. Natalia, there's just some updated information. They say that the garage is being used to store a classic car, and it is a separate building, separately deeded.
Okay. Well, I think earlier Larry mentioned that it's in breach of the declaration to allow the rental of a separate garage, from my understanding. So if that is the case and the owner is in violation and the tenant or whoever's renting the storage unit is in violation of the declaration, as Sonja mentioned, there are those enforcement steps that should be taken. First, documentation and ensuring that this is actually happening, and then to provide notice to the owner that he's not permitted to rent out his garage to this person. And then if that doesn't work, and if the owner doesn't take reasonable steps to comply with the declaration, then to take further enforcement steps. And if this is something that pertains to, I see an update again, we are ready to go to CAT. Well, that was the next thing I was going to say. CAT does have jurisdiction over storage on the common element. So if this is a common element space, which from my understanding earlier, it's a separately deeded area, you can go to CAT, but if it's not a common element, then you wouldn't be able to go to CAT on this one.
Thanks. Patricia, any thoughts?
I think it's also important when you're managing risk. You can also have in your bylaws, or actually, I think it should be in your declaration, a confirmation that if a party or unit owner escalates the risk and causes the insurance costs of the corporation to increase, that unit owner should be responsible for the increase in the premium. We're seeing that more in declarations. It's hard to calculate, but it's a good thing for people to bump up against, to understand that the risk of their operation should be allocated back to them, especially if in this market that we're coming out of, which is the hard insurance market, we want to make sure that insurance is affordable and accessible.
Good point. And speaking of insurance, there's another question that just popped up, and I'm going to make this the last question. Tricia, this is for you. Insurance is always a hot topic. Does asking the corporation's insurance broker about a tenant, sorry, my chat just bumped, about a tenant that caused a flood lead to an increase in the corporation's premiums, even if a claim isn't made?
That's a great question, and I get that a lot. And one of the perks of having a broker is the broker is the intermediary between the condo corporation and the insurance company. The broker doesn't work for the insurance company. The broker works for the corporation. So that advice is part of what you get as having a contract with that broker. And I would absolutely ask that question. And the broker does not have to notify the insurer unless there's risk of further damage to the structure or the corporate, like further into the corporation itself.
Thanks, Tricia. And on that note, we're going to have to wrap up today's webinar. As always, these go by so fast, but lots of great information today. And I just noticed that the whole panel today is a group of amazing women in the condo industry. So thank you to all of you for joining us today. And thank you to our speakers. I'd also like to take this opportunity to once again thank our sponsors. And don't forget to reach out to our sponsors, give them a shout, thank them for their support. We have Macintosh Perry, Registon Building, Restoration Limited, Common Ground Condo Law, Brown and Beatty, and Elia Associates Condominium Lawyers. Thank you again to all of our sponsors for supporting us today and making this webinar available at no charge. I'd like to also take this opportunity to remind everybody about upcoming events. So next month, March 24th, we have our next webinar that goes from 12 to 1 p.m. And we're switching from tenants in condos to short-term rentals. And you're going to want to join us because short-term rentals are different than tenants. So you'll have to join us on March 24th to find out why. Then on May 12th, Tricia's going to come back because we're going to have a panel of insurance brokers to talk about insurance in condos. And on June 16th, we're going to talk about nuisance and talk about what a nuisance. So don't forget, if you want to register for any of our webinars, go to our website, ccihuronia.com, and you can register online for all of our webinars. They go from 12 to 1 p.m. on Fridays, one Friday every month. Also, don't forget that we have our 2-day intensive director's course coming up on April 22nd and 23rd. Details of the course agenda are now on our website. Registration is open. And really exciting, CCI has launched a CCI Director Certificate Program, which is a new initiative. And the Director Certificate Program includes 8 Ontario-wide fundamental courses. And we are going to be offering 2 of these courses at our 2-day intensive director's course on April 22nd and 23rd as part of the cost of registration for that course. We're going to be talking, we're going to be covering the 101 Governance Fundamentals course and the 108 Repair, Maintenance, and Change Fundamentals course. So if you are working toward your director certificate, this intensive course on April 22nd and 23rd is going to get you 2 courses closer to finishing that certificate program. And don't forget also that a recording of today's webinar will be posted on our website probably within the next 7 to 10 days. Don't forget to join us on Facebook and on LinkedIn. If you want to get onto our mailing list so that you know what's happening at our chapter, send an email to admin@ccihuronia.com to be added to our email list. And as always, we'd like to make sure that you're aware of other events that are happening at our other Ontario chapters. So on February 25th, which is tomorrow, CCI Toronto has their Condo Strength, Condo Governance session. You can go to ccitoronto.org to find out more information and register. CCI Golden Horseshoe on March 9th is going to be talking about budget, audit, and financial statements. This is actually another one of the fundamentals course for the director's certificate. So you can go to cci-ghc.ca and you can take the fundamental courses for the director's certificate at any chapter. So you can do one with CCI Huronia and one with CCI Golden Horseshoe. They will all count toward that certificate program. And then CCI London on March 15th is going to be talking about insurance risk management for boards, owners, and all. CCI Eastern Ontario, our friends in Ottawa, on February 28th are going to be doing a session called Call to Duty. Whose duty is it? You can register at cci-easternontario.ca. On March 22nd, CCI Grand River is doing a session on navigating bad behavior and mental health in condos. You can register at cci-grc.ca. And if you want to know about any other events at any of our chapters across the country, go to the cci.ca national website page. There is a calendar in the bottom right-hand corner, and you can see what all of our chapters are doing. So that's it for us today. Until next time, I'm Sonja Hodis from the entire CCI family to yours, wishing you a great weekend. And we hope to see you on March 24th when we discuss short-term rentals. Don't forget, CCI is your condo connection.